Let's move into our one work session item for the day. This is docket 2022.07.078, Northwestern Energy. This is the general rate case. The commission is here to consider a final decision on Northwestern's general rate case. Mr. Hamilton.
Thank you, Mr. President and commissioners. For the record, for the people who are listening online, my name is Lucas Hamilton. I am the Chief Legal Counsel here at the Montana Public Service Commission and Department of Public Service Regulation. With me today are most of the regulatory division staff in the agency. And so as commissioners have questions as we go through this presentation, please do feel free to interrupt. I will pass any questions that I can't answer on to our very capable regulatory staff. So as you mentioned, Mr. President, we're here today to discuss the draft final order in Northwestern Energy's general rate case. This is a rate case that concerns both the electric and natural gas utility services provided by Northwestern. Our presentation today will start by going over some of the reasons for the rate case, at least as asserted by Northwestern Energy in their application materials, supporting documents produced in rebuttal, and then move into a breakdown of the core concepts behind this rate-making process, the factors that the commission staff considered in analyzing the reasonable range of possible outcomes here to identify whether the settlement agreement falls within that reasonable range. And then we'll finally conclude with some background on other miscellaneous issues, non-financial issues that were addressed during the course of this rate case. So as I said, we'll begin with the reasons for the rate case. There has been some years between Northwestern's last rate cases for electric service and for natural gas service and this current rate case. The last base rates for electric service for Northwestern were set in this 2018 docket, 2018.02.012. That's based on a test year with no unmeasurable changes, but based on a test year for the year 2017. So that has been some years ago. Additionally, for the natural gas base rates at least have been in effect for much longer. That's a 2016 docket based on a 2015 test year. So there has been some time that has passed since the last Northwestern Energy base rate cases. Northwestern has asserted that in that intervening time, it has invested in capital additions, in particular, $835 million in capital additions to the electric system and $267 million in capital additions to the natural gas system. Since the last applicable test periods, Northwestern asserts that its net rate base has increased by $453 million for the electric service and $143 million for natural gas service. It's important to note that approximately 40%, at least based on Northwestern's original application, the rates that they had originally requested, their asserted rates, approximately 40% of that was due to the flow-through costs for market power purchases and property taxes, which under Montana law, the Montana legislature has given us some guidance on how to treat the flow-through costs for market power purchases and property taxes. And so there is limited commission discretion under those statutes to deny the flow-through of those costs. Property tax increases in particular are worth a special note. For electric service, Northwestern's rebuttal testimony shows that $14,529,164 to be unnecessarily precise is the increase in property tax for the electric service, and $4.1 million is the property tax increase for the natural gas service. So property taxes are a substantial element of the overall rate increases that we're about to discuss. But before we do that, let's touch on some general rate making concepts. As many of the public commenters noted today, we have a diverse group of interests that intervened in this case, representing, yes, industrial customers, the large customer group, Walmart, and the like. We had the federal executive agencies participating in the settlement agreement. We had a variety of consumer and environmental interests participating who did not sign on to the settlement agreement. But it's important to note that we also had the Montana Consumer Council participating throughout this case, and that the Montana Consumer Council was a party to the settlement agreement. They did sign onto that agreement. There's an important statute in Montana Code within Title 69 that requires the commission to defer the representation of customer interests to the Montana Consumer Council when they intervene and participate in these rate increase cases. So that is an important concept of the statutory structure of both the Montana Public Service Commission and the Montana Consumer Council, which is created by the Constitution and has certain special rights in commission contested cases. So let's talk a little bit about how we calculate a total amount of revenue that NorthWestern Energy requires. The formula on your screen here is the general revenue requirement formula with all of its variables defined. This provides a useful guide for determining what sort of rate increase is reasonable for a utility like NorthWestern. We will touch on a few of these elements in greater detail as we work through. Certainly within the draft final order, these elements are discussed in even greater detail than we'll cover in our oral presentation, at least today. But of course, if commissioners have questions, we will be glad to talk about any particular elements. It's also important to keep in mind that the U.S. Supreme Court has established certain standards that we have to be mindful of and in fact follow when setting rates for regulated utilities like NorthWestern. And these are the Hope and Bluefield standards, which you've seen cited many times throughout the parties' briefs. A utility's ROE, which stands for return on equity, should be commensurate with the ROEs of businesses with similar risk. The ROE should be sufficient to maintain the financial integrity of the utility, and it should be adequate to enable a utility to attract investors and capital on reasonable terms. And these are important principles, especially when we start talking about the overall rate of return, and of course, more specifically, the return on equity that is calculated as part of this formula, which I'll flash back to. That rate of return includes an element of the return on equity, important in deriving the overall revenue requirement for NorthWestern Energy. Let's also talk briefly about some principles of rate allocation. Different customer classes within the utility's customer base can impose different burdens on the utility systems. This includes the transmission system, the distribution system, and in fact, the generation. Under general principles of utility rate making, customers that impose a greater burden on the utility system should likewise bear a greater share of the overall system cost. It's also important to remember, though, that regulatory bodies like the Commission may see value in moderating the impact of steep rate increases. And it may be reasonable to protect a customer class from the full cost of the burdens that class imposes upon the system. So with that, I'll pivot now to the electric revenue requirement, which is maybe the single largest disputed issue based on the representations of the parties in the proceedings and the interest of the public in general. Staff's analysis of the record evidence in this case results in a zone of reasonableness, a range of possible reasonable outcomes for the electric revenue requirement increase. And that range is from $71.3 million on the low end up to $90.6 million on the high end. Staff's low end analysis, that $71.3 million, is based on NorthWestern's rebuttal's position with certain adjustments advocated for by the parties in this case, including adjustments to the depreciation expense, which would drive down the revenue requirement. Frankly, all of these bullet points here are adjustments that drive down NorthWestern's rebuttal position for a revenue requirement, but the depreciation expenses come down, incentive compensation expenses come down, stock-based compensation for non-executive and members of the board of directors for NorthWestern Energy. Those are all downward adjustments to the revenue requirement. And perhaps most significantly, the return on equity, or ROE, is reduced downward to a range of, well, to a figure of 9.19%. I'll pause briefly to talk about the two stock-based compensation bullet points here. Earlier on in the proceeding, NorthWestern gave up its request for rate base, for revenue requirement to reflect the stock-based compensation for executive employees. So the effect of these adjustments to the low end of the reasonable range is that there is no stock-based compensation approved or considered as a reasonable outcome in this low end analysis. Moving to the high end analysis, to get to the $90.6 million, we still have the adjustments for stock-based compensation for non-executives and members of the board. Same point that I made before applies here. These are downward adjustments to the overall revenue requirement. It also acknowledges that NorthWestern has already withdrawn its request for recovery of stock-based compensation for executive employees. We've also still reduced the ROE requested here to 9.78%. So flipping very briefly back to the former slide, you'll see highlighted in yellow depreciation and incentive compensation expenses as the two elements that change along with the ROE in order to derive this high-end revenue requirement analysis that arrives at $90.6 million. About half of the difference, that delta between the high and the low end of staff's range of reasonableness, is due to the high and low end ROEs, those rates of return, return on equity. The high and low ends for depreciation and incentive compensation each account for about 25% of the overall difference. This order approves, the draft order in front of you approves the settlement agreement's stipulated $81.9 million increase, and that increase is calculated based on a 9.65% return on equity. Both the revenue requirement and the return on equity fall within the zone of reasonableness that was discussed on those prior two slides. The increase approved is still $23.2 million less than NorthWestern's requested increase of $105.1 million, I guess you could say. So it's still a substantial decrease from NorthWestern Energy's rebuttal position. NorthWestern's interim rate, which the commission approved and became effective back in October 1 of 2022, has already increased its electric-based revenue requirement by $29.3 million. In addition, the electric-based revenue requirement rates increased by $10.7 million, effective on January 1 of 2023 to reflect increases in property taxes for NorthWestern's electric utility assets. Of the $81.9 million approved, $40.1 million is already reflected in the current rates that are being paid by customers. Compared to rates that include the interim and the tax tracker adjustments, the bill for an average residential customer using 750 kilowatt hours per month will increase by about $8 or 7.6%. However, it's important to note that there's also been a substantial reduction to the PCAM under collection as a result of the commission's interim order in this docket. And so we'll discuss those in our next section, which hits on the electric supply costs. The order approves a PCAM base. This is the power costs and credits adjustment mechanism, the method by which NorthWestern collects that pass-through of the cost of providing energy to its customers, the supply costs, at least, of providing energy. This is an increase of $69.6 million or 50.2%, compared to the prior PCAM base set by this commission, which was $138.6 million. The PCAM base adjustment is important because it affects the overall cost sharing within the PCAM. As you're all aware, NorthWestern Energy, for certain categories of costs within the PCAM, is only allowed to recover 90% of its under-collected balance. So, in other words, over the course of a year, when it goes out and buys energy or it buys the fuel to run its own generators, those costs are tracked, and if NorthWestern's base rates are not sufficient to pay those full costs, they have an undercollected balance. And NorthWestern Energy is only entitled to collect 90% of that undercollected balance. The effect of increasing the PCAM base means that there will be a smaller undercollected balance for NorthWestern to come back and request recovery from customers, and a lower percentage of cost sharing borne by NorthWestern's shareholders. So the interim order in this case approved a PCAM base of $199.8 million, and that became, as I mentioned earlier, effective on October 1, 2022. The PCAM base approved in this order is an increase of an additional $8.4 million, or 4.2% from NorthWestern's current PCAM base rates. So $8.4 million above the $199.8 that was previously approved. There are also some PCAM is all financial, but there were also some changes that NorthWestern Energy requested with respect to the mechanism of the PCAM. Many of those were withdrawn or rejected as part of the stipulation and settlement agreement. It's important to note that in this case, as a result of the draft final order before you, Capacity costs will still be subject to the 90-10 cost sharing that I mentioned before. The PCAM will be subject to quarterly adjustments. Those quarterly adjustments will help ensure the overall undercollected balance or overall overcollected balance, if that happens, is smaller at the end of the year. By adjusting those rates on a quarterly basis, you should expect to see smaller overall deferred account balances.
Sorry to interrupt, Mr. Hamilton, but I think for public clarification, so if the quarterly adjustment is adopted, customers will better be able to see their bill reflect what the actual market conditions are. Isn't that correct?
Mr. President, Commissioners, that is a correct statement. Yes.
Can you provide some more nuance on that, please?
Certainly. Mr. President and Commissioners, and I would certainly invite any regulatory staff if you'd like to jump in on this, or if I say anything that you disagree with. The principle of the quarterly adjustment is that over time, the price for the commodity of natural gas or coal or market energy will change. And it may have, certain commodities may have a cyclical price cycle. At the time that we are using energy under the current system, the PCAM rates are set annually. And so it may not reflect the current seasonality or the current spikes or troughs in those prices of energy or of the commodities that are required to run the generating facilities. By switching to quarterly adjustments, you will then find a closer tracking of the actual costs and a more accurate reflection on customers' bills of the actual cost of supplying energy. And with that, I'll pass it over to Gary.
Morning, Mr. Duncan.
Morning, Mr. President. Mr. President and Commissioners, on that specific topic of the adjustments, what I would add would be an example of what has happened under the present mechanism, which is for the last tracking period for 2021 to 2022, NorthWestern actually undercollected by about $52 million. So what that is basically that's power costs that NorthWestern had paid, okay? And typically those costs are passed through to customers, but in this case, because of the mechanism, they were not able to pass those costs through. So NorthWestern carried a significant $50 to $60 million undercollection for over a year. And the bad thing about that is then on October 1st of last year, they were allowed to begin collecting that $53 million. It actually had accrued the year before. So customers were in the position of, they're not realizing that their usage was driving this undercollection, okay? It's not, they had no way of knowing this. They had no way to adjust their consumption without getting an accurate bill. Okay. So all of a sudden they're put in the position of October 1st of 2022, paying $50 million for power that had been consumed year before. Okay. So that's a very bad situation for NorthWestern. It was a very bad situation for customers, and these quarterly adjustments should alleviate that situation. I don't think we'll see that kind of occurrence again.
Thank you for that clarification.
All right. Thank you, Mr. President. Carrying on to a point that actually dovetails neatly with what Gary just mentioned. One other mechanism change within the PCAM is that interest would be applied symmetrically on any deferred balances. And what we mean by interest is in the example that Gary just brought up, where NorthWestern had substantially undercollected their actual supply costs, there would be an interest rate applied to that to reflect the carrying cost, what they're out by carrying that debt for ratepayers. It's applied symmetrically, however. So if NorthWestern Energy ends up over collecting, in other words, their costs come in below the base rates set under this draft order, then interest would also accrue to the benefit of customers. This next slide actually also dovetails nicely with what Gary just mentioned. On October 1 of last year, two rates changed at the same time. The interim rate the commission approved in this docket, and the interim PCAM true-up in docket 2022.09.083. And that was the $52 million under collection that Gary just referenced. So that true-up began collecting from customers $52 million over the course of 12 months. The PCAM, which is the second bullet I have on this slide. Third bullet is the important one. The interim approved in this docket raised that PCAM base rate up to a target collection of $199.8 million, which was an increase of $61.1 million. As a result of changing that base rate, the undercollected balance for the current tracking period, in other words, July 1, 2023 through July 1, 2022. That's a typo on my slide here. I apologize. July 1, 2022 through June 30th of 2023. The undercollected balance dropped. It dropped from $52 million to what NorthWestern has reported, at least initially here in the PCAM docket, of $17.5 million. As a result of that decrease, the change in the deferred balance that has to be collected, on October 1 of this year, customers realized a bill decrease of, well, assuming it's the average monthly bill of 750 kilowatt hours, a customer would see a decrease of $4.51 or 4.11%. The net effect of these two things happening at the same time is worth mentioning. It doesn't change the fact that the draft final order in this case is ultimately a rate increase as shown on this slide. But the effect of the commission raising the PCAM base back in October has affected the PCAM in such a way that it bears mentioning. The net effect of the current PCAM reduction that took effect on October 1 of this year and the commission's decision today would be about a $3.50 or 3.3% increase in the average monthly residential customer bill. Note, however, that we are headed into colder weather, so we should expect usage to increase for customers across the board, and as a result, bills will increase across the board. Moving on to the electric rate allocation and design. This order allocates the increased electric revenue requirement, that $81 million, as discussed in the previous slides, across NorthWestern's customer classes in a manner that does move closer to that general rate-making principle of cost causation, where the cost causer also becomes the cost payer. I say it moves closer, but not entirely. The rate allocations are described on this slide. GS1 primary and GS2 transmission have a 0% allocation of the rate increase, moving all the way up to residential customers at an 18.2% increase. This order accepts the electric rate design agreed to by the settling parties, which includes minimal changes to the current rate designs. Only the GS2 substation class receives an increase in the monthly service charge, that fixed charge as part of the electric service bill. On this slide, third bullet point is worth noting. Under the stipulation and settlement agreement, the parties had agreed to consolidate all the different lighting rate tariff categories. However, as of this morning, it has been processed in ready. NorthWestern filed a notice of the withdrawal of this particular request to consolidate the lighting rate categories. So it appears that it is just infeasible for NorthWestern to carry out that element of their original proposal discussed in the testimony of Cindy Fang. And so as a result, this element of the draft final order will need to change to reflect that the request has been withdrawn. I'll move now to the natural gas revenue requirement. Staff's analysis of the record in this case produces a zone of reasonableness that ranges from $15.8 million increase to $23.1 million. That $15.8 million figure is based on adjustments to NorthWestern's rebuttal testimony. Again, the adjustments are listed here as with the electric revenue requirement. Downward adjustments for depreciation, incentive compensation expenses, stock-based compensation, natural gas production asset step down, which we'll discuss in a little bit greater detail further on, and an ROE that was reduced to 9.19%. Those adjustments lead to the low end of the reasonable range. The high end also includes some downward adjustments from NorthWestern's rebuttal position. This includes adjustments for stock-based compensation, for the natural gas production asset step down, and still a downward adjustment to the ROE, bringing it to 9.78%. Again, as I did before, I'll flip backwards to highlight that the differences in the low end and high end are primarily attributable to depreciation, incentive compensation expense, and that ROE changing between the two scenarios. The order approves the settlement agreements. The draft order in front of you approves the settlement agreements stipulated natural gas revenue requirement increase of $18.2 million. It's important to note, though, that we are now in the year 2023, and as a result, the natural gas production asset step down kicks in. And in fact, in this current year, that requires a reduction of $738,000. The resulting natural gas revenue requirement increase would therefore be $17.4 million. The increase approved in this order is a $9.1 million reduction from the $26.5 million increase that NorthWestern requested in its rebuttal position. The interim increase for the natural gas side that the commission authorized to begin on October 1 of last year was $1.7 million. In addition, the natural gas revenue requirement increased by $2.8 million effective on January 1 of last year as a result of NorthWestern Energy's tax tracker docket. So of the $17.4 million approved in this order, $4.5 million is already being reflected in the rates currently paid by NorthWestern's customers. Compared to natural gas-based revenues generated in the interim and property tax adjustments, the increase is 8.3%. It's important to discuss this, though, in the context of the overall natural gas supply charges. Natural gas supply charges have dropped significantly. The average monthly bill for a residential customer was actually higher in August 2022 than it would be under the rates approved in this order due to that reduction in the natural gas supply charges. All things considered, the average bill, if you assume an average use of 65 therms per month, would actually drop $8.74 or 12.8% between August 2022 and the rates described in this order. And again, that is because it is a substantial drop in the natural gas supply charges. I want to obscure the fact that this is, as we'll discuss later, still a rate increase for customers, but in the overall sense of where we stand today with supply charges as they are, it is still a decrease from the prior year. Yes.
Quick question for you, Mr. Hamilton, just for public consumption. How does Northwest Energy obtain its natural gas?
Mr. President,
Why?
yeah, if I could, I would love to pass that one on to one of regulatory so I can take a break from talking.
Mr. Duncan?
Mr. President, Northwestern, number one, has some of its own production assets up on the High Line. And I believe the last numbers I saw was that they produce about 16% of Northwestern's natural gas requirements. The rest they go to the market. They buy it on the market. They do try in the summer to buy gas when it's cheaper, and they put it into storage. But storage capacity does not meet their requirements during times of higher need. But basically, they're getting 85% of their gas they're buying it on the open market.
So the obvious follow-up to that, Mr. Duncan, does the Public Service Commission in any way approve or disapprove of open market purchases?
Mr. President, the answer to that is no.
Thank you, Mr. Duncan.
Mr. President, can I ask a question while we're on this point here? Lucas, I want to be sure that I'm understanding something I think very important that you've covered here to this point, and that is that all things considered, the net effect of this draft order that's before us today, if it's approved, will result in a $3.50 per month increase on the average monthly residential customer's electric bill over what they are currently paying. Is that correct?
Mr. President and Vice President, yes, I believe that is a correct statement.
And as far as natural gas residents, the average monthly bill would see a decrease of $8.74 compared to what they were paying when this rate case was filed in August of 2022. Is that correct?
Mr. President, Vice President, that is correct. Once you normalize for usage, you're assuming a monthly usage of 65 therms. Yes.
Okay. Thank you. I think this is certainly better news than most of us were expecting. So thank you.
Mr.
Mr. Duncan.
President, Vice President Fielder, I might just add a couple of things to that. And that is, back in August of 2022, okay, for the average residential customer, their gas commodity bill was $36 a month. And that was over 50% of their total gas bill. Okay, the other 48% was for the transmission, distribution, and storage. So over half of their gas bill was the gas commodity, which is passed through by NorthWestern. There's no profit on it. It's a pure pass through. Those prices have fallen as of October 1st the gas commodity have fallen 38%. Okay, so now the average gas customer using using 65 therms a month, their gas bill is about $22. So that's a very, very significant decrease. It actually got worse last fall because from August up into like September and October, the gas prices rose even more astronomically. So the actual decrease since, say, October last year is significantly more than 37%.
That's very good news. Thank you. Appreciate that.
Thank you, Gary. Carrying on to the natural gas rate allocation and design. Approximately a 14% increase is allocated for residential employees, utilities, DBU firm transmission. Well, I'm not going to go through all of the list here, but for all the classes listed here, you would expect to see 14% increase. For residential general service and the storage customer classes, you could expect to see an 11% increase as a result of the rate allocation described in the draft final order and within the stipulation and settlement agreement. The order also accepts the natural gas rate design that was agreed to by the settling parties. And with this rate design, only non-residential classes receive an increase in the monthly service charges. Converse of that means, of course, that residential customer classes would not receive an increase in their monthly service charges. So I'll move now into another element that was very hotly contested throughout the rate case, and that is this concept of the 3 riders that NorthWestern Energy proposed. First was the reliability rider. Under the stipulation and settlement agreement, this rider is not approved, as discussed in the draft order. The stipulating parties agreed that NorthWestern may request a one-time PCAM base cost adjustment when YCGS, otherwise known as the Yellowstone County Generating Station, otherwise known as the Laurel Generating Station before it, when that is placed in service. Now, if filed, that application must include all the information that the commission requires for a prudency review. Sorry, do we have a question? Okay. So the draft order details fairly exhaustively many of the elements that are involved in a prudency review that we would expect to see if NorthWestern decides to go down this road of filing for a one-time PCAM base cost adjustment. This is very important, the third bullet. The order does not limit any non-settling party's ability to object to the filing, including on procedural grounds, including on the grounds that it is single-issue rate making. As discussed in the draft order, this discussion of the PCAM base cost one-time adjustment is an agreement only between the settling parties. Doesn't bind the commission to pursue it, doesn't bind any of the parties to go along with it either. But other than, of course, the settling parties have agreed not to object on procedural grounds. It'll still require full prudency analysis if it's done, and the commission will still, I am confident, hear arguments from parties about whether it should even be considered in the first place. So that is all preserved within the context of the draft final order. And Gary would like to add too.
I'd like to add a comment about the prudency of Yellowstone generating station. As you know, at the hearing, many parties questioned the prudency of building the Yellowstone gas. It was quite an issue. And there was much discussion about what type of prudency review would be done on that, when it would be done. So I'm pleased that the way our order has come out on this, because number one, you need to understand that there is not one dime of Yellowstone County generating station money in the current rate. Zero. Okay. The first attempt by NorthWestern to recover that would be through this one-time PCAM filing, which they have said will take place near the time of when the plant goes into service. What they would be asking for in that filing is to recover essentially their operating costs for that plant through the PCAM, not the rate basing of the asset or putting it into or earning on that asset. They would not do that until they file the general rate case. But the way this thing is set up now is that before any costs of Yellowstone generating station, including the operating costs through the PCAM, would be approved by this commission, there is going to be a full prudency hearing on the Yellowstone County generating station. And we went through and listed all the items they filed in their pre-approval docket when they first, when they filed for Yellowstone County generating station, stating that that's the minimum amount of information we expect to see, and that this will be open to all interested parties, and that there may be significant more information required. So I'm fully confident that that plant's going to get a full prudency review with all interested parties having the opportunity to participate.
So, Mr. Duncan, Mr. Hamilton, I generally don't refer to public comment, but because it's not a part of the record in this matter, but I think we had some confusion this morning in the public comment about what happens for treatment of the Laurel or YCGS plant in this matter. And as I understand from you, Mr. Duncan, if this draft order is approved, we are not approving any recovery for that plant. Is that correct?
That's correct. There was no dollars, operating expense, taxes, depreciation, any rate, nothing was asked for Yellowstone generating station in this rate case. There's nothing in it at the current time.
Thank you, Mr. Duncan. Mr. Hamilton.
All right. Thank you, Mr. President. Moving on to the next rider, business technology rider. Fairly simple outcome here. It's simply not approved. No special terms to discuss either in this settlement agreement or in the draft final order. It is simply rejected. There was also a wildfire mitigation rider. This is again not approved as a result of the draft final order and the settlement agreement between the parties. The settling parties did agree that NorthWestern may defer and accumulate incremental wildfire mitigation expenses subject to annual caps, which were specified in the settlement and are incorporated into the draft final order. Deferred expenses would be eligible for recovery in a future rate case, subject to a complete commission prudence determination. So again, this is a zero impact in the short term. All of this does is allow NorthWestern to track all of their expenses up to those caps and then make a case for the recovery of those expenses in a future proceeding. Let's turn now to a few miscellaneous issues that don't neatly fit in any of the prior categories, beginning with demand side management. NorthWestern had originally proposed in their application to capitalize the costs of demand side management, or DSM. As a result of this settlement agreement and the draft final order, those costs will not be capitalized. They will continue to be recovered through the PCAM, which we discussed in great detail before. And the DSM program will be the subject of future working group discussions. And this dovetails into the next topic, which is the fixed cost recovery mechanism. The commission had originally approved a fixed cost recovery mechanism, or FCRM, in NorthWestern's last electric rate case, docket 2018.02.012. That pilot program never really got off the ground. And as a result of the stipulation and the draft final order, it would be eliminated officially. Future FCRM options would be the subject of continuing working group discussions. And in the draft final order, those discussions are directed into the new advisory committee. It's not a new advisory committee, but the advisory committee that has got new parameters on it as a result of the commission's rulemaking on integrated resource planning and recent statutory changes. So the discussion will continue on both the FCRM and DSM. Let's turn now to the small natural gas production asset acquisitions. As a result of the settlement agreement, as a result of the draft final order, NorthWestern may defer and accumulate costs associated with the acquisition of small natural gas production assets. Much like the wildfire mitigation rider expenses that we discussed before, these will be subject to a future prudence review. It is not included in rates at this point. They are merely allowed to track them and seek recovery for them outside of the normal principles of test year rate making. Let's turn now to the Sleepy Hollow gas system. The commission is very familiar with this one. After the case we went through last year, NorthWestern acquired that Sleepy Hollow gas system, which is located near Winifred, Montana, near Lewistown. NorthWestern's natural gas rate base and operating maintenance expenses for the natural gas side of their utility do reflect the acquisition of Sleepy Hollow. Under the draft final order, NorthWestern may defer and accumulate any costs that exceed the 2022 known and measurable expense adjustment. And those deferred costs, again, will be subject to a future prudence review if NorthWestern seeks recovery of them in a later rate case. So in conclusion, question before the commission is whether to adopt the draft final order as the commission's final order in this proceeding. If the commission decides to approve the draft final order, we would also recommend that you authorize staff to make non-substantive revisions to improve accuracy and clarity. Admittedly, the draft final order includes some typos, includes some errors that impede the accuracy and clarity of the writing. These, however, would be non-substantive changes, so you should expect, if you authorize staff to do this, that the resolution of all these key issues would remain the same. So with that, I will happily stand for any questions that the commission may have and offer my regulatory colleagues as well.
Mr. Duncan, anything to add?
Commissioners, I would add that I think as Vice President Fielder knows, when this thing was first filed, we were trying to figure out how many pages this thing was. So as you may remember, we got a ruler and measured it. And I think we came up with an estimate of 10,000 pages. And since that time, the record in this thing has grown significantly. There's tens of thousands of pages of additional material that has been filed in this, additional testimony, discovery, all sorts of stuff. The commission staff basically had about 12 or 13 staffers that have worked on this over the last 14 months. Everything from accountants to economists, attorneys. I can guarantee you there have been thousands of hours of work that have gone into looking at this. And these things are not inexpensive. Based on the costs of the last general rate case from NorthWestern, at that time, the rate case expense was estimated at, I believe, about $1.5 million. I suspect we're north of $2 million for all the parties involved in this. So my point being is that from a staff perspective, all of the issues in this, and there were far more issues than just the revenue requirement, all of the issues have gotten, from a staff perspective, a very thorough vetting. And I believe that staff is comfortable in saying that that ultimately the settlement is probably a fair outcome of all these issues.
Thank you, Mr. Duncan. You hit on a number of issues that I was going to talk about in my remarks. I will take this opportunity because I was going to do it as part of my remarks if my colleagues would indulge me here. I take great umbrage when people come in and question the fairness and impartiality of our staff. It's inappropriate, frankly. And an example that I'm going to give you about the dedication of our staff is that Mr. Duncan actually retired and came back to work on this case. Ms. Umstead, anything to weigh in on? Ms. Gobert, thank you. All right, Any questions? We're going to go a little unusual on the order here. Generally, we don't allow questions before we make the motion, but I think this is weighty and substantive enough that if any commissioner has questions, this would be a good time to ask them. All right.
Not a question, Mr. President, but I just wanted to follow up on what you were saying. And what Mr. Duncan talked about, and that is there was I think more than one of the people that were, the consumers, the public that commented this morning used the term rubber stamping. And one of them, I'm disappointed that he left after his photo session. So hopefully he will listen to this later. But so if I could just make some comments to that.
Sure.
Allegation of rubber stamping, again, following up on what you said and what you said, this might seem a little redundant, but I still want to express myself and my appreciation to the PSC staff, my gratitude to their diligent work, including but not limited to the way the final, draft order was written. The details and understandable explanations provide the public an inkling of insight into the sophisticated and thorough analysis done by the PSC, tens of thousands of pages of data, graphs, tables, thousands of hours, you said, models, arguments, and applying those that information to formulas, including the revenue requirements. So, so I take umbrage as well when people talk about rubber stamping, when I know how hard you work, and I so appreciate your hard work.
Commissioner Panochi. Sure. Any other questions at this point in time? Seeing none, I would entertain a motion. Commissioner Bukacek.
I move to approve the 103-page final draft order as the final decision in NorthWestern's general rate case. Rates approved to be effective for service rendered on and after November 1st of 2023, and authorize staff to make non-substantive edits to improve accuracy and clarity.
Is there a second? I'll second. So we have motion and second. Discussion, Vice President Fielding.
Mr. President, thank you. And I also wish to thank our staff for their excellent analysis, the deep and thorough review that this case has received by not only the staff, but commissioners as well over these last 13 months. I would like to be able to say no to any cost increases. This country is seeing astounding cost increases across the board in every way, and none of us like it. But the reality is we have to follow the law, and we have to allow utility companies that we regulate to recover their legitimate expenses. We have to allow them the opportunity to earn a fair rate of return on their investment risk. We are bound by law. We cannot simply say no. Regarding my concerns with this case, I'm pleased to see that what the customer, the average residential electric customer, will notice on their bill after this order goes into effect, if it is approved today, will be a mild increase of $3.50 a month as a result of this decision, and a decrease in their natural gas monthly average of almost $9 a month, less than what they were paying when this case was filed in 2022. Again, I will repeat that is very good news that I don't think any of us were expecting. I do have one outstanding issue, Mr. President, with the case that has not been addressed. And I understand that the rate base has largely remained stagnant over the last 4 or 5 years since the last case was determined and a final order was issued by this commission. And since then, admittedly, NorthWestern Energy's made significant investment to improve its transmission system and keep it in good repair. NorthWestern has also paid substantial increases in property taxes, which by law are passed straight through to the customer. That is the legislature's decision, and the Public Service Commission has no say in that. Local governments do, though. Local governments set tax rates. The state sets tax rates. This commission does not. But one important thing that we do have a say in is whether or not NorthWestern Energy's investments are prudent. And while it is hard to deny the critical importance of replacing dilapidated power lines and power poles, I do still have reservations regarding NorthWestern Energy's multi-million-dollar expenditure to replace nearly all of its existing residential gas and electric meters, many of which still had years of useful life left in them. Achieving the system benefits and enhanced customer services enabled by NorthWestern Energy's new advanced metering infrastructure, also known as smart meters, might make some stranded investment reasonably necessary, but in my view, that depends on the value of those benefits exceeding the amount of the stranded investment. And I'm concerned that NorthWestern Energy did not present the commission with a full economic analysis that quantifies those benefits and costs. I'm concerned that premature retirement of thousands of perfectly good meters may not have been a prudent decision. In this case, if the settlement agreement today is approved, if this order is approved, only about 40% of NorthWestern's expected total AMI investment will be reflected in rates. For that reason, I do not believe it's necessary to reject the settlement agreement over these concerns. However, I would like to move to amend the commission's final order, Mr. President, to A, direct NorthWestern in its next relevant rate case to present a full economic analysis of the expected benefits of AMI, its AMI system, compared to the stranded costs for existing metering infrastructure, and demonstrate how NorthWestern Energy's management considered those benefits and costs in the decision-making process that resulted in their AMI project. And also to reserve the right of the commission to conduct a prudency review of the entire AMI project at that time. This motion includes allowing staff to work with commission leadership on drafting the amendment if staff deems additional clarification regarding the reason and intent of this motion would be helpful.
All right, we have a motion on the table. Is there a second? Commissioner Bukacek?
I second.
We have a motion and second discussion.
Oh, colleagues,
Vice President Fielder?
yes, colleagues, I would appreciate your support on this. It allows us to take a closer look at what we didn't receive good and thorough information on regarding the deployment of the advanced metering infrastructure project and potential prudency of those investments.
Commissioner Bukacek?
Based on extensive study, I recognize the importance, I think you could probably say essential nature of having advanced metering to implement grid modernization. So I acknowledge that, but I also recognize legitimate citizen concerns. So I will vote yes for the amendment.
Further discussion? Discussion? I think we could probably do this one on voice vote. So we'll start there. All those in favor of the Vice President's motion signify by saying aye.
Aye.
Did we lose? Commissioner O'Donnell, were you on?
I am here, Mr. President. I vote aye.
Okay, thank you. All those opposed signify by saying no. Seeing no opposition, that motion carries. So we are back on the main motion as amended. Further discussion? Vice President Fielder, I think you had the floor at that.
I just thank my colleagues for supporting that motion, and with that caveat, I will be supporting the underlying motion today. Thank you.
Okay, Commissioner O'Donnell.
Thank you, Mr. President. This is, as I expressed in meetings yesterday, this is a great concern to me. I appreciate, I think it was Mr. Hamilton and yourself, I believe, to make a very, very important point. is that the many people who have contacted us and even this morning asked us to deny the rate case entirely are simply not aware that we are subject to federal and state requirements and regulations. It is not within our authority to simply say no to this rate increase. I'm sure that Senator Dunwell understands that we're not trying to be in a position where we flaunt regulations that are imposed on us by the state and federal laws. One thing I've learned in my 6.5 years, almost 7 years on the commission here, is that rate making is science. It's not an exact science, but it is science. And a lot of work has been put into by staff and commissioners, as Commissioner Fielder mentions, into discussions about this and researching into it. As I expressed just the other day, I understand the point of view that Mr. Hamilton pointed out about the rate causer and the effect upon the apportionment of rate classes. I fully understand that. At the same time, one of the things that has been very important to me was a comment that I immediately had appreciation for of former Commissioner Lake, using as a standard basically the proverbial little old lady on a fixed income who has no elasticity to her ability to absorb costs, that an increase of cost one place has to be taken from some other place, in many cases an essential or required thing at another place. It seems to me that residential class, as a class, certain parts of it have no ability to increase their income on their own. Businesses, however, by definition, have that capacity. I understand about the fairness of the classes. I had made myself very clear over several years that I believe that as Commissioner Fielder mentioned, no rate increases are palatable. They're always difficult. But I think that the balance should be tipped in the favor of residential use in terms of rates. I've mentioned that for years as a guiding principle of mine. I see that it has been, it comes into confrontation with the cost causer principle, which is a solid economic principle and rate making principle. So I'm not saying that anybody is wrong on there. I is simply pointing out my preference on what I think would be a more beneficial method of rate making. Again, I in terms of rate making being a science, but not an exact science, my very simplified attitude towards rate making is that ratepayers should not pay a penny extra more than what they are required to, and the utility should not receive 1 penny more than what they need. That is, we're talking about 1 penny, that's exact. However, as I say, rate making is not an exact science, and it has to be with a lot of estimations and assumptions, and I fully appreciate that. My purpose of my commentary today is to point out that the comments that many of the interveners and testifiers have made are absolutely valid. and they're very meaningful to me. I feel that the research and recommendations of staff are not arbitrary and capricious. They're based upon solid and acceptable and procedural precedent, and that all parties deserve to have us follow precedent so that we're not dealing with surprises and that nobody can count on. Having said that, I am reluctantly, with several misgivings, I will vote aye. But anyway, I wish to thank the staff again, as others have said, for the tremendous diligence on working this through. It has not been easy. The other thing I wanted to mention is that in terms of stipulations, as I have made clear in the past, I do not like stipulations. I would rather go to the mat on this. I understand one of the staff attorneys pointed out to me that the work on this thing was as close as possible to taking Northwestern to the mat on this. I really appreciate that. There are several questions that have been raised that have come into my mind that maybe were elaborated earlier, but that my more mature thought has given me more questions that I would like to ask of the parties in the case, but that time has passed. So again, Mr. President, thank you for this opportunity, and I yield. Thank you.
Thank you, Commissioner O'Donnell. Commissioner Pernocci.
Thank you, Mr. President. I want the listeners and the ratepayers of Montana to know your comments are important to me. I believe they're important to other commissioners as well. And I listen very closely to the things you have brought up to me in the last few months, in the last year. There's a lot of concern over the new gas plant being fossil fuel. And I'd like to ask Mr. Hamilton a few questions where him and I have worked on some things together. Mr. Hamilton, you and I have worked closely on a high efficiency docket over the past couple of years here. And trying to meet those goals of high efficiency and meet a lot of the questions the ratepayers bring up. Yesterday, we brought in Leslie Joya from out of state, works at a university, and he very clearly explained that we can put carbon capture on a gas plant. We can mix fuel with hydrogen, which would cut carbon emissions down to half if we were able to do a 50-50 mix. So in your opinion, we can do a lot with this plant to answer a lot of questions that were brought up and concerns with the public about fossil fuel and carbon release. Can you tell us a little bit about that?
Mr. President, Commissioner Pernocci, at this stage, I think it would be premature for the commission to judge what particular outcome is necessary for CU4, what technology may or may not be available for CU4. It's important in the context of this rate case to focus on the record that was developed over the 6-day hearing, over the voluminous filings that Mr. Duncan referred to earlier. So I would be very hesitant to pass any sort of judgment about what happened in yesterday's meeting with respect to, is it Mr. Joya's presentation?
Is it fair to say, though, that the concerns that have been brought up, there are answers to, and that the possibility exists for a gas plant to use a mix of hydrogen, reducing CO2, that the possibility exists for carbon capture, so there is no carbon release of a gas plant. I think it's unfair for people to bring those concerns up without understanding that there are real answers and that I'm bringing people to the commission to explain some answers. Do you think it's fair to say that those possibilities exist to meet those concerns that the ratepayers brought up?
Mr. President and Commissioner Pinocci, I think that there are two sort of premises built into that question. One, is it technically feasible based on current technology? And two, is it financially feasible? Is it the right decision for ratepayers for Northwestern and Montana? And on both of those questions, I do believe that's a question for a later proceeding, that it would not be appropriate to answer at this point. It'll require development of record evidence on both counts as to whether or not something like that is possible in the future.
I think that's a fair answer from you, but I sure want the public to know that I've been working very hard on their concerns when they keep bringing up that this is a fossil fuel plant, and we're going backwards when the technology exists to fix all of their concerns. So let's talk a little bit about high efficiency power lines. Looks like Northwest Energy's installed some, and this will save millions of dollars of line loss. And it looks like in the future they have plans to install more. When we install high efficiency power lines, there's a higher upfront cost, but it will cut the fire risk by half. It'll cut line loss by a third, and that savings will be shared with the ratepayer. And with this rate increase, this may allow them to install more of this high efficiency power line. Do you think that's a fair statement?
Mr. President and Commissioner Pinocci, it is true that Northwestern has installed some higher efficiency power lines as was over recent history. And as those assets are installed on their system and become used and useful, they will be included in that rate base, which is an important element of the calculation of a revenue requirement, or in this case, a range of acceptable revenue requirements. I don't believe that I've fully answered your question at this point, but I'm not sure that I have a way of answering the question based on the record evidence that I can recall off the top of my head. If you wouldn't mind, would you mind repeating the tail end of your question?
Well, I think that we talked a little bit about the aging power lines across the state. If we could replace those with high efficiency power lines, would cut the line loss by a third, and there'd be a rate of return. For instance, changing all the gas meters when their useful life isn't maybe even at half yet, there may not be any gain financially to the ratepayer, but replacing power lines that would cut the line loss, people understanding that electricity radiates out of the line, we can cut that by a third, would save millions of dollars. That seems like that would be a better goal to replace the power lines and gas meters. Just an example for a benefit to the ratepayer. With this rate increase, this might allow them to get some of that aging power line replaced with high efficiency power lines. There's several gains there. One, we can double the capacity of any line that's the same size, which would free up lines that are at near capacity. Two, it would cut fires by half because of the carbon core, reducing sag. But more importantly, we'd cut the line loss by a third. Would this rate increase help maybe with the more expensive line to be installed, and there'd be a savings in fire mitigation, freeing up grid capacity because we can double capacity and saving a third? There'd be a rate of return over the next 100 years as those lines are in. They'd pay for themselves and save money to the ratepayer. Do you think that's a possibility, that if they get this rate increase, that will help with that?
Mr. President and Commissioner Pinocci, I'll address a few things first as a general matter of accounting. And I am just an attorney, so don't trust me when it comes to accounting necessarily. But if you are replacing a fully depreciated asset with a brand new, upgrade or reinstallation, you should expect to see the rate base increase. And as a general matter, that will increase rates in the short term, as you've acknowledged. To the extent that there are efficiencies provided by new assets. Northwestern would not need to generate energy. Northwestern would not need to go buy energy from the market. Those savings would be passed through to customers on the supply mechanism, the PCAM. As to whether any particular line needs to be replaced or will be replaced in the near future, and I do expect that Northwestern will continue to make capital investments after this rate case. To the extent that any particular line needs to be replaced or is prudently and reasonably replaced with a high efficiency power line, that is a determination of prudency that would be the subject of a future contested case and would therefore be something that the commission needs to refrain from opining on at this point and leave for the development of that future factual record.
Let's talk a little bit about adding a power plant in Montana. We don't produce enough electricity to supply Montana, and we go on the open market. Sometimes we have to pay 10 times more for it. By adding the power plant in Laurel, is it fair to say that they will save consumer money?
Mr. Hamilton, I'm going to direct you not to answer that question. That's going well beyond the scope of this order. In fact, you're getting into decisions that the commission might make in short order, in fact. So can you move on to the next question, Commissioner Panochi?
I'm under a lot of pressure here because I vote against rate increases more than anyone I know. And I'm having a lot of people telling me not to do this, and I'm trying to justify why it is I think the rate increase needs to happen. So that's what I'm trying to do here. Okay. Let's talk a little bit about natural gas. The town of Winifred was run by Sleepy Hollow, which went out of business, and NorthWestern Energy wasn't able to step in and take over Sleepy Hollow. Is it fair to say that the residents of Sleepy Hollow would have had to move to propane, including the school and all the businesses?
Mr. Hamilton, to the extent that you can answer that.
Mr. President, Commissioner Panochi, I may not be the best person to answer that one because I did not work on that case. But if the utility system that was Sleepy Hollow had failed, had needed to be shut down due to safety concerns, then I think it's fairly accurate to say that yes, there would have been a substantial need in the service territory formerly served by Sleepy Hollow to convert to something else. But as the commission is aware from the prior case, NorthWestern did step in and assume operational control of that utility. And now in this rate case, you do see the beginnings of recovery for the Sleepy Hollow gas system.
Is it a fact that Sleepy Hollow customers are paying less for natural gas now than they were?
Mr. President and Commissioner Panochi, I don't have facts to answer that question. I don't know if anybody else.
I was told their rates were lowered after NorthWestern took over the natural gas.
Mr. President and Commissioner Panochi, I can neither confirm nor deny.
Thank you, Mr. President. No more questions.
Thank you, Commissioner Panochi. Before I call on Commissioner Bukacek, I think it might be helpful, Mr. Hamilton, for public consumption for a short primer on rate design and generally how increases are allocated to the different customer classes. And then once that's answered, I'd like to query you about legal standards as related to that. So I don't know who wants to step up and provide a basic primer.
Mr. President, if I can volunteer Haley to provide a background on the embedded cost of service and rate design.
Ms. Gobert, thank you.
Mr.
Welcome.
President, just to clarify, you're asking for clarification on how parties take the revenue requirement and then allocate that to particular customer classes?
Correct. And then, of course, how we would review that for accuracy.
Well, parties, at least in this case, NorthWestern, presented their application. There was a proposed revenue requirement in there. The other parties take that and they develop their own cost of service study. There is a variety of ways a party can take that. There's no right or wrong way. There's a variety of ways to functionalize and classify the embedded cost of service. And so parties proposals for allocating revenue requirements are influenced by their proposals for moderating, using principles of gradualism and equity across customer classes. The parties' cost of service based class revenue allocations, as I said, are based on that initial revenue requirement, and parties have different views on how to reduce those allocations. And so it is difficult for staff to provide a zone of reasonableness in this area. But so as staff, we use more qualitative basis using those cost of service study results and those moderated recommendations kind of as a guide. There's, different allocators and things like that the parties will use. Cost allocation and rate design is more of an art than a science, and varying, policy decisions go into those different allocations. But as we talked about earlier, rate making principles such as the cost causer are the foundation of that. And so it's using that theory that different customer classes should, their rate should reflect the utilities cost to serve their customer load. If you have anything more particular, I can elucidate, but that is kind of a very rough presentation of that.
Ms. Gilbert, always want to emphasize your name. Mr. Hamilton, during the evidentiary portion of this matter, were cost of service studies entered into the record in this matter?
Mr. President, yes.
And when it comes to our decision-making as a commission, are we required by general principles of administrative procedures and/or common law to look at what evidence is presented to the commission in order to make decisions?
Mr. President, yes, your findings of fact must be based on record evidence.
And do you recall, Mr. Hamilton, who conducted the cost of service surveys in this matter?
There were a number studies performed off the top of my head, I believe NorthWestern Energy, Montana Consumer Council, a large customer group. Did the federal executive agencies join?
I believe yes, I believe Walmart was also presented a class cost of service study.
And so essentially, as I understand how it works, and I have a pretty good understanding how this process works, frankly, after 19 years of legal practice, essentially what we do then as a commission, of course, is we look at those studies and results, and we determine the reasonableness, if you will, or the lawfulness of the cost allocation based on evidence that's presented to the commission, correct?
Mr. President, that is correct. You judge the credibility of all the record evidence in making your findings.
And so to that regard, the allocation to the residential class in this case, which we all recognize is substantial, it would be hard to say or to allege that the commission is somehow approving a final order that would be arbitrary and capricious, correct, in terms of customer class allocation.
Mr. President and commissioners, it is true that the embedded cost of service studies that were provided in this record indicate that at present, residential customer class is paying less than the burden that it imposes upon the system. And so there is evidentiary support for moving towards more of what Haley described as that cost causation principle, the according to certain parties in the proceeding, the more just outcome where the cost causers become more closely related to the cost payers. I will say that it's not 100% in that direction, as noted in my presentation earlier. There are still concepts of moderation and gradualism that come into play here that still produce an overall sort of cost shifting away from that residential customer class and into other customer classes.
Mr. Hamilton, this is why you're an excellent chief legal counsel. You're kind of going where I wanted you to go. And so, as I recall, during the substantial hearing in terms of time and days that was held in this matter, one of the concerns certainly that was expressed by, I would say, if I may call them the settling parties, is that if the commission engaged that there was a recognition that the residential class was being subsidized by other classes, correct?
Mr. President, that is correct. It's recognized, I would go so far as to say, even in the Montana Consumer Council's testimony and advocacy.
Correct. And so when the public or other parties or commissioners express concern about the allocation that, if you will, that the residential class is receiving, which is a concern to every single one of us, and I repeat that again, it's not because the commission decided to single out residential customers for a high increase. It's because it's what the evidence and argument in this matter would otherwise support, correct, based on cost causer principles.
Mr. President, that is correct to my understanding.
Thank you. Commissioner Bukacek.
So listening carefully to the public commenters today and in the past, it's already been talked about. There are a lot of misunderstandings. You could even call it confusion, among the public. And so of all the things that were expressed today that I consider to be misunderstandings, I picked my top 3, and you've pretty much covered, I think, all of them to a great extent. The last one is recognition that the larger consumer classes do subsidize the residential ones. So that's a misunderstanding. Another one that I'd like you to clarify is the misunderstanding. It was stated by somebody that it's the PSC's job to, quote, I think this is a quote, to protect consumers from utility monopolies. I believe that was stated this morning. And I think you covered that adequately when you discussed the Montana Consumer Council. So I don't think we need to anything more about that. And we already covered what a big concern I had about that business of rubber stamping. So is this the time that we give our final comments? Mine are very brief.
Yes, it is.
It is. All right. With your indulgence, Mr. President, but I will be brief in part because so much of what I wanted to say was covered very, very well, especially by Vice President Fielder. So I really have not much more to say. In very brief summary, and thank you so much. Outstanding work on that oral presentation and all the follow-up that the staff gave. I'm considering that energy utility companies provide services that are needed for basic comforts and even survival for ratepayers. It should be fairly obvious that they be given reasonable opportunity to recover prudently incurred costs so they can continue to provide these essential services to the ratepayers. Making a decision in the public interest involves weighing the evidence, which in this case supports approving the settlement. Thank you.
Thank you, Commissioner Bukacek. I think we have a clarifying question from Vice President Field and Mr. Hamilton.
Thank you, Mr. President. Yes, Mr. Hamilton, regarding the fact that NorthWestern has withdrawn part of its request to consolidate the lighting, do we need a motion to remove that from the draft order? And if so, could you state how that motion would be best phrased, please?
Mr. President and Vice President and Commissioners, it's a very good question. As it is currently addressed in the draft order, the lighting tariff changes, which were proposed in I believe it's the rebuttal testimony of Cindy Fang, were agreed upon by the stipulating parties and then approved by the commission. So at a minimum, to recognize the withdrawal of NorthWestern's proposal, it would be prudent to amend, if not delete entirely, that paragraph as it is currently written. Procedurally, since the commission has adopted one amendment to the draft final order, I do think it makes sense to follow in that method of approaching it by amending out the approval of the consolidation of the lighting tariff changes. And as with the prior amendment, I believe that, an amendment stated in those terms will be clear enough to staff about what our direction is in revising that final order, that we can accomplish the commission's goal.
Would Vice President Fielder accommodate us in that regard, please?
Yes, Mr. President, I move that the draft order before us be amended to take the consolidation of the lighting tariff changes out of the order and to have staff create the proper language, necessary language to do that.
I'll second that motion. Discussion? Seeing none, we'll just take a voice vote on this. All those in favor of the Vice President Fielder's motion to amend the amended motion, the underlying amended motion, signify by saying aye.
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 Aye. We lost Commissioner O'Donnell. Well, that's disappointing, to say the least. We will hold this hearing in abeyance at this point. I would just note for the minutes, of course, that we were in the midst of taking a vote on Commissioner Fielder's motion. Why don't we take 7 minutes to see if we can get Commissioner O'Donnell back on the line, please. We will stand in recess until 12:20.
I am reconnected.
Commissioner O'Donnell.
Hello?
Commissioner O'Donnell, we're glad to
Can
have
you hear me now?
Yes, we can.
Oh, thank you.
Yes,
Okay,
we can.
good.
Glad to have you back. We missed you.
So nice to be missed.
All right, so time is now 12:22 p.m. We'll go back on the record in our business meeting. Where we had left off before Commissioner O'Donnell dropped off proceedings today was that Vice President Fielder had offered a motion to amend the already amended underlying motion to. Did you want to restate your motion, in fact, please?
Yes, Mr. President, thank you. I had moved that the draft order be amended to remove consolidation of the lighting tariff changes and that staff draft appropriate language to do that.
And then I had
Hmm.
second that.
And
Mhm.
And Mr. President, the purpose of the motion is, I believe that's a moot point since Northwestern has withdrawn that provision.
Thank you for the clarification. Okay, Commissioner O'Donnell, did you want to speak to this motion?
No, thank you.
Okay. All right, then let's try this again. We'll do a voice vote on Vice President Fielder's motion. All those in favor of the Vice President's motion signify by saying aye.
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 All those opposed signify by saying no. Seeing no opposition, motion carries. So we are now back on the original twice amended motion. Before I make my remarks, does any commissioner have any additional remarks or questions for staff? All right, seeing none. All right, colleagues. Good meeting today. I appreciate the work of the staff and their presentation. Very helpful, I think, for public understanding. I also thank those who participated today during the public comments section. I appreciate their interest in this matter and their willingness to step up and provide us their thoughts. I think, as Commissioner Pinocci stated, public input is important and we appreciate it. I will be voting to issue the draft final order in this matter as now twice amended as the final order of the commission. As my colleagues have pointed out, this matter is of significant public interest and directly impacts the economic interests of NorthWestern Energy and its customers. That is why we had multiple parties seek intervention in this case. And that's why we had multiple parties actively participate in the multi-day hearing that was held in this matter in April of this year. As my colleagues are aware, as commissioners, our duty in these proceedings such as this is to balance the interests of regulated entities such as NorthWestern Energy and the customers it serves. We carry out these duties with an eye towards ensuring that Montana's regulated energy utilities are financially healthy such that those utilities are able to provide power to their customers at the moment those customers demand it. Our duties are made even more solemn when all of us understand that access to safe and reliable power is at times a matter of life and death, particularly during those periods of extreme winter weather. And we're reminded that by the arrival of our first snowstorm today. In order to carry out responsibilities accorded to us in our elected positions, we are required to make tough decisions. I have heard earlier that I take umbrage when people question the integrity of our staff. I do not, however, take umbrage when people criticize us as commissioners because we're elected officials and we have stepped up into this position. It is fair to criticize us. If people so desire, it is not fair to criticize our staff. Often these decisions will be unpopular because such decisions will result in increased utility bills for everyday Montanans. You have heard today from my colleagues that the commission fully recognizes that an increase in any necessity, particularly power bill, causes hardship, particularly as Commissioner O'Donnell noted for those on fixed income, because as Commissioner O'Donnell appropriately noted, there's no way for them to otherwise pass on increased cost to anyone else. And we recognize that. The diligence with which we make decisions related to rate increases is particularly pressing at a time when we're seeing poor policy decisions coming out of Washington, D.C. that are resulting in skyrocketing inflation rates, supply chain issues, and exploding consumer costs for Montanans struggling to make ends meet. However, our decisions are supportable if we do what is legally required of the Commission in cases such as this, which is to apply the evidence presented to us during the contested case process to what the law and regulatory principles require. Instead of carefully considering the evidence presented to us, it would certainly be simpler, as Vice President Fielder noted, for commissioners to just merely vote no on any and all rate increases, because frankly, it'd be the politically expedient thing to do. But automatically voting no without first carefully considering and weighing the mountain of testimonial and evidentiary evidence presented to this commission during the contested case process does not satisfy our duties as decision makers. With this stated, after careful consideration of all the testimony and evidence presented in this matter, and I want the record to note, for purposes of any legal challenge to this, that I have read the entire record. I participated in every day of the hearing, and I have based my decision based on the record, testimonial, written evidence, and the testimony provided at hearing, and on no other factor. I have concluded that approving the filed settlement agreement and as thoroughly vetted through the nearly 2-week-long hearing process conducted in this matter meets the required legal standards for approval. That is, the proposed rates and rate design meet the legal standard we apply of being just and reasonable. Again, for public consumption, the standard isn't that we disapprove rates based on whether or not we want to. Our jobs are to determine whether the rates proposed are just and reasonable. Further, the total revenue requirement contained in the settlement falls well within the range of reasonableness, as that range has been determined by the Commission after months of careful study and detailed internal analysis. These legal conclusions in support of approving the settlement agreement are made more supportable by the fact that during the lengthy hearing held in this matter, not a single one of the non-settling parties, and I'd like to get this on the record, put on any evidence or testimony that meaningfully challenged the electric base revenue requirement nor the gas revenue requirement as the same is and was forth in the settlement. That's a matter of evidentiary record. I reached this conclusion even though there are adjustments that, in the absence of the settlement agreement, I would have adopted that may have resulted in the lowering of the total final rate increase being considered today. These areas include accepting the Montana Consumer Council's proposed incentive compensation adjustments, as well as MCC's proposed adjustments to the stock-based compensation for non-executive employees and for the board of directors. What is more, as my colleagues will recall, during the hearing held in this matter, I asked a series of questions of NorthWestern Energy witnesses regarding whether a 3-year average for the FERC transmission credit, as the same as set forth in the settlement, should be approved. In my view, based on the responses provided at the hearing, I would go with the 2-year average, which would be a more supportable outcome. And I think Mr. Duncan agrees with me on that. But that's not what we're voting on today. Even so, as stated, the PSC staff has concluded, and I agree that, Commissioner Pinocci, can you ask those that are doing construction to please wait? Well, this has been an interesting hearing. Thank you for providing that service, Commissioner Pinocci. As you know, today, this PSC staff has concluded, and I agree, given the uncontested evidence, the commission finds itself in a place where the commission would be acting contrary to law and ignore what the evidence informs us as to what is a reasonable and supportable rate increase, particularly when making adjustments to the revenue requirement may compound the already existing problem in the settlement where the residential customer class is being subsidized by other classes. You heard me have a colloquy on that. The fact of the matter is, as I've noted in my comments, I am as concerned as all of my colleagues about the amount of increase that's being allocated to the residential class. But it's not an arbitrary, capricious decision to do so on part of the commission. It's what the evidence inform us should legally happen. There are other factors that militate in favor of supporting issuing the draft final order. First, the Montana Constitution makes clear it is the Montana Consumer Council, and there seems to be much public confusion on this. And I appreciate Commissioner Bukacek reinforcing it, but I'm going to reinforce reinforcement. It is the Montana Consumer Council, not the commission or intervening parties, that advocate on behalf of the interests of consumers of regulated utilities. Certainly, we have intervening parties that come in and represent their particular rate class customers, but it's the Montana Consumer Council that is under the Montana Constitution designated as the representative of customers of regulated utilities. It is not the commission. Why is this important to this decision in this case? It is because the Consumer Council is a party to the settlement agreement before us. And in that capacity, the ratepayers representative has averred to us, the commission, its approval on behalf of NorthWestern's utility customers that adoption of the settlement is, one, in the best interest of the ratepayer, and two, the proposed rate increase is reasonable. Second, and this is extraordinary, and Vice President Fielder already touched on this, but the public clearly doesn't understand that, and so it needs reinforcement. Some 18% of the total increase for electric rates is directly attributable to paying for increased property taxes. As I have previously noted in prior dockets, the Montana legislature has directed the commission to approve as a pass-through to customers property tax increases. For those that would like to double check that, that is found in Montana Code annotated 69-3-308. You can look it up if you're interested. Therefore, due to legislative decree, true increase approved by the commission amounts to roughly $67 million when one backs out the $14.5 million in tax increases. Same is true on the natural gas side. Of the stipulated $8.2 million natural gas increase, some $4.2 million or 23% of that increase is due to property tax increases. I think Commissioner Fielder stated it aptly. If you have concern about that, you have other elected officials you can certainly speak to, members of the Montana legislature or your local government officials. Thus, the property tax portion of the rate increase is directly attributable to decisions being made by the legislature or more often local governments, not the commission, as the Vice President pointed out. Again, as a matter of law, Commission is prohibited from denying NorthWestern Energy recovery for these expenses. And frankly, it'd be against the law for us to deny recovery for those expenses, which I don't think the public understands either. We'd be acting against the public interest if we were to deny those expenses. Second, and further, as my colleagues inherently understand, every business incurs operating and maintenance expenses. Such expenses ensure that the utility satisfies the commission's goals of ensuring that NorthWestern Energy provides reliable energy upon customer demand. To this end, some 30% of the electric revenue requirement is dedicated to operation and maintenance expenses. These are expenses on their face, reasonably incurred expenses. It makes sense for the utility to maintain and preserve its major assets, such as its transmission lines and generation assets. As to the latter, the transmission lines, we all know, as commissioners, of the interest in having alternative forms of energy in Montana grow and expand. Well, they will only do so if NorthWestern's transmission lines are there to provide the capability to move power. As to the gas increase, some 20% of the increase is directly attributable to operating and maintenance expenses. Again, a reasonable and expected business expense and cost. During the course of this proceeding, the commission heard from some in the public taking issue with NorthWestern Energy or any other regulated utility for that matter, earning a return on their capital investments. In fact, I probably hear about this complaint more than any other thing I hear as a public service commissioner. However, for public awareness, the public may not be aware that the United States Supreme Court has expressly held that regulated utilities, including the one involved in this case, are, quote, and I quote, entitled, that's the word they use, to have an opportunity to earn a fair return on the value of their investment. Therefore, if we don't, as a commission, allow Northwest Energy or any other regulated utility to earn a fair return on their investment, we would be acting contrary to law and the public good. Contrary to what some have claimed, a fair return does not mean no return for the utility on its investments. Any demands to the contrary are not only unreasonable, such demands request the commission ignore established law, as I have stated. To this end, the public should know that NorthWestern Energy has represented to the commission that it has invested some $835 million in its electric system since 2017. And the public should know that Northwest Energy represents that has invested over $267 million into its natural gas system since the year 2015. These investments go to serving the public as is required by law as a regulated utility in order to meet what is required of them as a regulated utility. Much of this investment has been directed to the area of transmission improvements and upgrades, which I know Commissioner Pinocci has taken a keen interest in, and he has done so rightly. These investments are prudent given the rapid expansion of integrated and need to integrate renewable generation onto NorthWestern Energy's existing transmission system in order to meet carbon goals, as was discussed during the hearing in this matter. Again, these investments evidence that NorthWestern is meeting its obligation to provide safe and reliable energy to its customers. Further, the commission's final order is supportable because it addresses concerns that were raised by the non-settling parties to this case. To wit, during the hearing held in this matter, several non-settling parties raised great and strong concern regarding NorthWestern Energy's proposed reliability rider. These concerns are addressed in favor of the non-settling parties by the adoption of the settlement agreement, as NorthWestern has agreed in paragraph 15 of the settlement to withdraw its request for approval of the rider. What is more, there was significant opposition from the non-settling parties and the Montana Consumer Council as to NorthWestern's request to capitalize demand-side management costs moving forward, thereby removing them from the PCAM sharing mechanism. Mr. Hamilton talked about how the PCAM sharing mechanism works. In substance, it works that Northwest Energy has to assume a portion of its cost without being able to charge it to the ratepayers if they don't operate their utility prudently. Okay. This proposal too is not adopted in the draft commission order. Thus, this issue has been resolved in favor of those who oppose Northwestern's original demand side management request. What is more, the order grants the request of intervening parties, namely HRC and NRDC, to establish a more robust stakeholder process to discuss and put forward consensus-based solutions relating to alternative rate-making approaches, principles, etc. So the commission is granting a request of one of the non-settling parties. As noted in the draft order, all of us at the commission recognize the value of demand-side management programs, and frankly, as power generation comes offline at a rate faster than we're able to replace it, demand-side management programs are going to become even more important in the future. As a result of this order should facilitate discussions that may result in customer savings moving forward. In closing, this order is the product of much deliberation and thorough review. It is a product of nearly 2-week hearing process. Multiple parties representing public interest groups to customer class groups participated in these proceedings and offered their input. The commission has gone out of its way to provide opportunities of the members of the general public to weigh in on these proceedings. Most critically, this order is the product of nearly 6 months of careful analysis by the excellent PSC staff. Certainly, I have received some questions from the public, and namely members of the legislature, what was taking so long for us to issue or to consider the matter today. And the reason is because the staff was engaging in a thorough review of the request, given the magnitude of the request. Cause and effect. I recognize and thank our staff for their work. I thank our colleagues for their thoughtful and reasoned positions as well. Again, I want to thank you, Mr. Duncan, for coming out of retirement and helping us. Very gracious. We wish you happy and joyful retirement. And I'm sure more than anybody, you're pleased that today has come. So again, colleagues, I encourage you to vote to issue the draft final order in this matter as twice amended as the final order of the commission. All right. Anything else from commissioners? Question? Call the question. All right, we are going to do a roll call vote on this one. This is a matter of some public importance, to say the least. Vice President Fielder,
Aye.
Commissioner O'Donnell,
Aye.
Commissioner Pinochi,
Aye.
Commissioner Bukacek,
Aye.
and I am an aye as well. So motion as twice amended carries. All right. Thank you, everybody, for all your hard work and for your input this morning. Time is now 12:42 p.m. Seeing no further business to come before the commission as to this particular business meeting. I would just note for the record that we will be back on the regular Tuesday schedule. So our next commission business meeting is October 31st, spooky Halloween at 9:30 a.m. And I will adjourn today's meeting.